Good day, everybody. Thank you for all tuning in here. Today our topic of conversation is expert bias, the duty of an expert witness towards the court. And I'm very, very pleased to welcome Advocate Ferdinand Kehrhahn, Advocate of the High Court of South Africa. He's a student of the law. He's acted on the bench as acting judge at the Gauteng High Court, an academic, lectures at the University of Pretoria, and so on and so on. Counsel, thank you for joining us today.
It's lovely to be here. Thank you for inviting me.
Good. I know that this topic has a special interest for you. In fact, it's close to your heart. In 2023, you completed your doctorate, your thesis, and the heading, here it is, thank you for the copy here, it's Fire the Hired Gun, Eliminating Expert Bias in the Accusatorial-Adversarial Civil Justice System. So you're well read on the topic, and I think that you can give us a lot of insight and help us understand this. Starting off with the actual hired gun. In the legal fraternity, we know what that means, but it is quite harsh. But you must have thought about that as part of your title, to include that, the significance of that. Why did you think that along those lines?
Yeah, so today is not a very comfortable topic. It's a very morbid topic to talk about, or no less on a Friday. But the title plays a bit with words. Obviously, a hired gun means it's something that is, the services is solicited for a very specific task, and experts are then solicited to advance the narrative of a particular litigant in litigation. The expert is not hired for the purposes of being an objective witness to the court, but is hired to serve a particular purpose and to advance the case of the plaintiff or the defendant for that matter. And I played a bit with words in the title. Fire the hired gun means it's a gun, it's been fired, it's employed, but at the same time it means getting rid of it. And of course the thesis investigate ways in which adversarial bias can be eliminated, and that shouldn't be confused with other forms of biases such as tunnel vision and so on. So it deals specifically with bias that goes to the soliciting of expert evidence.
Yeah, okay, that's very interesting. But the fact that our judicial process, the litigation process itself, is adversarial, isn't it a breeding ground for bias, if we can put it that way? Doesn't it present a case where I'm paying you, so you must be biased towards me? As an attorney, you got to favor me, which we know is incorrect, but just the system itself.
Yeah, so how the law of expert evidence developed is experts or witnesses are taking up the same role as that of a lay witness in our court procedures. So they are being examined in chief, cross-examined and re-examined just like a lay witness would do. And invariably, the adversarial processes and procedures is a breeding ground for expert bias. And I think let's unpack that just ever so slightly. So the first problem is how experts are selected and introduced. And at this point, it's the parties who can elect the expert. Yes. And they can elect or nominate the expert from a large array of experts. So they can choose an expert who conforms to their particular narrative. So there may be a mainstream view, and there may be one or two individuals that goes against that mainstream view, and if that single expert will assist the litigant, that is the expert that the litigant can then elect to choose. It's done in secret, so you can search for whatever expert you choose, and the expert is being paid for by the attorney, and we'll get to that in a bit more detail later. But also, the legal profession, the expert looks to the legal professional for protection and for trial preparation, for experts for protection from adverse cross-examination. And then there's also the consultation with the patient, which renders, there's sympathy with the patient. And all of that results in the expert leaning over to favor that particular litigant, be that consciously or subconsciously. The other problem is fees. So, experts are there, they render a professional service. They do it for money. They don't do it for free, as you know.
Yes.
And they are also in it for their own advancement. So in the short term, they look to be paid compensation for an individual case, and they are paid well. But in the long term, they need further work from that particular lawyer. So they need to keep the lawyer happy. And the lawyers on their end is they work on a contingency fee basis for the most part. And they are then entitled to 25% of the capital or double the normal fee. So there's an incentive for the legal practitioner to have an inflated claim, because that means that their fees are so much higher. Then there's also the freedom of opinion. So experts can easily hide behind their opinion. They can say, well, it's professionalism and it's sincerity. It's my legitimate opinion and I'm entitled to that opinion. And experts have learned to manipulate the impact of their testimony separate from its value. So what that means is, well, perhaps I can explain it with a simple example. An educational psychologist may render an opinion that a child had the potential to obtain a degree. But that doesn't mean that there was that is what the probability was, or on a balance of probability that child would have obtained a degree. And in that way, the expert actually manipulate the impact of their testimony. And we see it often. And then finally, the battle of the experts. Experts get pitted against each other.
Yes.
It's the battle of the experts. So to use a simple example, there may be a general acceptance amongst a particular discipline. In practice, 98% of the members of that profession will buy into that particular narrative, and there may be 2% going against the grain. In court, it's a 50-50. So you don't find that percentage in court, and it sort of distort the real view out there.
Very good. And there's a lot of issues that got raised now that are in reality what's happening. We at FundaMedical, we actually strive to keep our experts up to date, what's happening in court, because I think the biggest thing for an expert, for anyone, but for an expert, is their reputation, and that shouldn't be tainted. So what we do at FundaMedical, we do training sessions, information sharing, mock trials. We keep our experts up to date with judgments. And the whole point is that when you write that report, you're there to help the court as an expert. You must present an objective report, and you actually must be able to back what you say. Your report must be beyond reproach and beyond criticism, especially from the court. And that's what we do to help our experts understand what's happening and the importance and significance of the role they play in court. What do you suggest we can do to bring that level of beyond reproach kind of thing of experts across the board, and that it's more prominent with all our experts?
Yes, I think you have to go back to the basics, and one have to remind ourselves what is the expert's duty towards the court. And ultimately, an expert does not belong to a party. An expert belongs to the court. So the first important thing is that the expert should not usurp the function of the court. The court makes the ultimate decision. The experts should not go beyond the scope of their discipline. We often find experts expressing an opinion which they are not qualified to express, which belongs home in a different discipline. The other important thing is that if an expert cannot express a view finally because of insufficient information, it's vital that that report states that this is an interim report. There are certain outstanding information. We see often that experts will say, well, I asked for a pay slip, I've asked for bank statements, I've asked for certain information, it didn't come, but then they still express an opinion. So that obviously has an adverse effect on the reliability. Facts should never be omitted from a report, even adverse facts. And, in practice we see that, for example, if there's a pre-existing condition, the experts don't investigate the impact of that pre-existing condition. They'll say, well, there was a previous accident, or the patient suffers from cancer or whatever, but they don't really say what was the impact of that pre-morbidly. Experts should also stay away from general assumptions and presumptions. Don't go to Koch scales, for example, if you can work with an actual income. Don't just accept the retirement age would have been at the age of 60 or 65. If, the point of the expert is there to assist in the quantification, and the expert must be put back in the position. The expert must put the patient back in the position that he would have been was it not for the accident.
Absolutely, and that's quite interesting what you state as well now, Counsel, because we have a situation where you could have the attorneys, the legal representatives, both on the plaintiff and defendant side, agreeing to a particular expert. And that's where an expert must not wear a plaintiff or a defendant cap. That's where you want the expert to apply himself, because the court's going to rely totally without an opposing expert.
Yes. So I think the most important thing for an expert is that you have to be able to defend your opinion. And the only way that an opinion can be defended is by giving reasons for an opinion. And that opinion must reasonably possibly be able to be held or to be submitted given the facts of an individual case. So that's, I think, probably the most important thing. Experts should also acquaint themselves with the basics on law of evidence. I find, I teach law of evidence, and I find that is a significant problem in practice. Experts, for instance, don't know that they are not allowed to give hearsay evidence, just like a lay witness is not allowed to do. At the same time, they also are not permitted to rely on the opinion of other experts. You can't have an industrial psychologist relying on an academic article from a clinical psychologist or a plastic surgeon, because they are not in a position to speak to the veracity of that opinion. So there's that basic education and training that I think can take place. But ultimately, your question was, what can you do better at FundaMedical? I think peer review is probably the best thing that you can incorporate, because it's only a peer that can understand the nuances that the rest of us, that's not a member of that particular discipline, can understand. And I think that's something that's significantly underutilized. So that's, I think, something that you can introduce.
Well said. And have you found in your time, whether you're a peer counsel or whether you're acting as a judge, do you find that the courts and the judges are becoming a little more conscious of what the expert's saying, not as accepting, questioning? Are they not letting the experts just get away with it? Or has the judiciary come to a point where they say, hold on, I have a problem in accepting unequivocally what you state? Is there more circumspection when it comes to experts?
Most certainly. There's no two ways about it. You will know that the RAF terminated their panel attorneys. So most of the matters against the RAF goes ahead on a default judgment basis. And they, even where they do defend the matters, they hardly ever appoint experts of their own. So it's really pretty much a one-direction approach to the litigation. and courts will, where there's an obvious defect in an expert opinion, will obviously not accept that opinion.
Yes.
So they've become exceptionally careful. I don't, sometimes they may even fight in the corner of the RAF, which is also something that is not healthy. But that's a discussion for
another day.
For another day. But the important thing is judges are ill-placed to really assess and adjudicate expert opinion. That's the paradox. The judges don't understand expert facts, and for that reason, they need expert assistance, and that's why we have expert witnesses. But at the same time, it's the judge who must adjudicate facts of an expert nature. And judges are not ill-placed. So although obvious deficits will be picked up on, for example, if there's over-exaggeration of a career ceiling,
yes.
That's something that falls, that a judge that's legally trained will be able to pick up on. But there are other nuances that they may not. For example, when an expert uses a test that had not been standardized, that's not appropriate culturally or from a language point of view, but that test is still used, and that it gives an incorrect result on which those type of errors or oversights is not something that can readily be picked up by a court or counsel or for that matter. And that's why I say peer review is ultimately the way to go.
Well put, yeah. Very interesting topic, and we could go on for hours. But in conclusion, if there would be one question that a personal injury attorney, whether it's plaintiff or defendant, should be asking himself before he relies on an expert report or an expert opinion, would you say that would be?
I think, are you comfortable that the name of your law firm is written at the bottom of that court order, given the facts and the circumstances of the case? Is the compensation that you ask the court to make with the evidence that you present, are you comfortable that that is fair and reasonable compensation? That's I think what should drive it.
Fair comment. Thanks very much. I think that this is something that we can explore again and unpack again maybe in a later series, but it's been an absolute pleasure in having you in our FundaChat today.
Thank you so much.
Thank you, Counsel.